Hello, everyone. This is Annie Cartwright. I'm an attorney in Husch Blackwell's education group. We're excited to present today on relevant laws and options for inquiring about criminal histories during college and university admissions processes and hiring processes as well. Before I begin, I'd like to cover a few housekeeping items. At the bottom of the audience console are multiple application icons for you to use during the program today. I'd like to take a minute to highlight some of the key ones. If you have any questions during the webcast, please submit them via the question box. We'll try to answer any questions during the webcast as time allows, but if a fuller answer is needed or we run out of time, we'll do our best to answer later via email. We really do appreciate audience participation and encourage you to submit any questions or constructive comments you may have. There's also an icon to assist you with your viewing preferences. Along those lines, note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area as well. If you have any technical difficulties, please click on the help icon. It has a question mark and provides information on common technical issues. A copy of today's slide deck is available in the resource list icon. It looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. Also, it's approved for HRCI and SHRM recertification credit for human resources professionals. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, you'll need to click on the CLE widget at the bottom of your screen and complete the questions. You'll also need your bar numbers for that. A recording of the webcast will be available tomorrow for watching and sharing. Once it's available, a link of the recording will be emailed to you along with your certificate of attendance. The link will be active for about 2 weeks. With that in mind, let's head to infinity and beyond the box. Joining me today is Alex Rushing. Alex is also a member of our education group, and she regularly counsels education clients on litigation, investigation, and as today, compliance issues arising from a wide variety of civil rights and educational funding issues. Where are we going to take you today? We are going to talk about a number of issues surrounding the use of criminal history information in admissions and hiring processes and how you can square your practices with law, policy, and your institutional missions and goals. Alex is going to spend some time talking about issues surrounding students, particular issues related to their needs, and then we'll turn to me and I will talk about similar issues as they relate to employees in the employment setting. And then we'll come together and talk about where these issues overlap and some best practices for considering and addressing the use of criminal history and asking about criminal history in both the student and employee processes. By way of background, the next several slides are going to take a look at some insights on the current state of the criminal justice system, the use of the box and what we mean when we talk about the box, and issues to consider when you're deciding whether to use the box at your institution and decisions regarding criminal history. Let's turn to our first poll question. Does your school ask students or employee applicants questions about criminal history? Yes, prior to the applicant being admitted or hired. Yes, but only after the applicant is admitted or hired. No, or I don't know. Please submit your answer, and then we will turn to the results. It looks like most of you, so far at least, ask about criminal history prior to an applicant being admitted or hired. So most of you probably use the box. What do we mean when we talk about the box? It's typically a checkbox on an application, either a student application or an employee application. It can have various levels of questions. It can ask about whether you've ever been disciplined for anything in your entire life, like the bar admission application does, and you have to write down the pink slips that you got for not wearing a proper uniform in high school. It can ask about arrests. Most commonly, it'll ask about convictions or felony convictions or incarceration. The timing of these can vary. Typically, and it looks like for most of you, you use this on your general application, but sometimes it's used on applications for program-specific activities or activities within your college and university setting where you don't ask that on the general application. Examples of that might be situations where students or employees are going to start to come in close contact with vulnerable populations like children or the elderly. We sometimes see parents or volunteers being asked to provide criminal history information if they are in a situation where that may be relevant to their role. And particularly in programs, healthcare programs or teaching programs or law enforcement programs, you will see the box in applications because to some extent it relates to licensing and the ability to complete a program. So what's the problem, or what are some of the challenges to the box? Basically, they're tied to the criminal justice system in the United States. We've seen a staggering growth in the number of individuals involved in the criminal justice situation just in the last 20 or 30 years. The U.S. accounts for less than 5% of the world's population, but almost 25% of its inmates. The average state and federal prison population has risen from 200,000 in 1973 to over 1.5 million. And in the last 40 years, not only have our prison populations escalated, but so have the number of people who are being arrested, placed on probation, or placed on parole. Our local jails hold another 700,000 people. That is carrying incarcerated or imprisoned people up to 2.2 million people. And along with those populations, we have an annual pipeline of people leaving them, leaving those institutions and trying to re-enter society. So our statistics are showing that certain groups, generally racial and ethnic minorities and males, are more likely to become involved in this criminal justice system, and they are more likely to encounter challenges when they're facing box situations on either employment or educational applications. Certain data indicates that these disparities can start pretty early, that they can start within the school setting, basically. Data from the Office for Civil Rights of the Department of Education from 2011 and 2012 showed that black students are suspended and expelled at a rate 3 times higher than white students, often for the same types of infractions. And while black students represent 16% of student enrollment, they represent 27% of the students referred to law enforcement or subjected to school-related arrests. So we're seeing that these students are often, if they're kicked out of school, if they're unable to complete their programs, they're more likely to end up in the juvenile justice system or in the adult justice system, and later eventually come out and need jobs or need additional education. A lot of schools, particularly mission-based schools, are looking for a way to play a role in breaking the cycle, in balancing what may be perceived as some inequities in the system. And research really does show that education can be a powerful pathway for people who've been involved in the justice system to transition back into the classroom or back into the workforce, and that it cuts the likelihood of them returning to prison by over 40%. In 2016, a publication from the Department of Education said that there's a growing recognition that successful reintegration back into society boosts the lives of those individuals, of their families, and generally of society as a whole. So given this, why are schools asking about the box? There are a lot of good reasons for doing that. One is that they want to learn as much as possible about their applicants. They want to know who is entering their student body for a variety of reasons. They may have an interest in diversity and promoting the entry of students into their communities who don't have the traditional pathway to college, or they might have very legitimate safety or litigation concerns. We live in a world where our number one priority for our students is safety for our communities. If we can't ensure safety, it's hard to fulfill our missions of providing education. And finally, sometimes we have concerns about our students' abilities to gain employment once they graduate from our program, if they're able to graduate from our program, or whether our employees are qualified for jobs that may call for things like professional licensure or may call for background checks where a criminal history would prohibit them from performing that job. Why do many people oppose the box? It comes back to this idea of potential discrimination. There may be a barrier where the box impacts various groups disproportionately. In short, those racial and gender groups have been shown to be more likely to be disciplined or arrested than others, and the box may perpetuate that because it complicates an already daunting college admissions or job application process. We saw one study out of SUNY where 62.5% of applicants who disclosed a prior felony conviction on their initial application never completed the application. So that 62.5% who didn't complete is compared with 21% of applicants without a criminal history who began their application process. So we're losing a great number of applicants where we're having people disclose their felony convictions ahead of time. And waiting to ask that question, particularly if we wait to ask that question and put into process some of the ideas that Alex and I are going to talk about later, where we give people an opportunity to explain or appeal or establish that they're ready for education or employment, may help bridge that gap and add to some diversity in our student body and our employee situations. There's also been shown to be no real correlation between safety on campus and asking prospective students and employees about past issues with the law. The Center for Community Alternatives found that there's no research that states that students with a criminal history are more likely to pose a threat. We don't have corresponding research for employees, but experience indicates that a lot of people who cause criminal-type problems on our campuses aren't people who actually have criminal histories. Another concern with the box is that often criminal history information is inaccurate. First, we can ask the question, and people can just lie about their criminal history, and then you have to ask yourself whether you have a process in place for following up on that. But more significantly, a lot of the data we get, if we're going, say, the background check route as opposed to the box check route, a lot of the information we can receive is either incomplete or inaccurate. On the FBI's III system that collects various data on crimes across the country, a lot of information is inaccurate, including dismissals and acquittals. So that database may show that somebody had an arrest or they have a pending lawsuit, but it was ultimately actually dismissed or they were acquitted, and it's going to show up as a negative criminal history. Also, our commercial databases are equally unreliable. They don't cover all states. Not all agencies and all states report to them. The FBI doesn't make its information available to many of them. And the reported information, again, it might not cover things like expungement or sealing records in a timely fashion. Also, private companies tend to use name-based background checking as opposed to more accurate fingerprint-based checking. If you have a common name, you've probably been confused with someone else in the past, and this can happen in the criminal history situation as well. So this background explains why we recommend using CARE when you're exploring criminal, student, and employee histories on campus. CARE that, of course, needs to be balanced with safety concerns and risk mitigation and legal requirements. And now we're going to turn to Alex to talk about some of the legal requirements, especially as they relate to students.
Thank you, Annie. So as Annie mentioned, this next section will focus on relevant law and standards about campus safety and the admission process for students specifically. Annie will touch on some of the concepts related to employees later on in the presentation, but some of the concepts that I'll cover during this portion are also applicable to employees as well. So we'll begin by talking about the Clery Act. In 1990, Congress enacted the Crime Awareness and Campus Security Act of 1990, which amended the Higher Education Act of 1965. And in 1998, the law was amended and renamed the Jean Clery Disclosure of Campus Security Policy and Campus Crime Statistics Act, or as most of us know it, the Clery Act. As you probably are aware, this act requires all post-secondary institutions participating in Title IV Student Financial Aid Assistance programs to disclose campus crime statistics and security information. The other backdrop to keep in mind is that federal law and many state laws prohibit discrimination based on protected class in post-secondary institution admissions, as listed on your slide. Specifically, Title VI and its regulations prohibit discrimination on the basis of race, color, and national origin, and Title IX prohibits discrimination based on sex. This means institutions cannot intentionally discriminate, and institutions must not implement policies that, even if on their face are neutral, have the unjustified effect of discriminating against individuals on the basis of a protected class. This unjustified effect, this concept, is often called disparate impact, and we'll explore that during the course of this presentation today. With disparate impact, it's important to note that a statistical disparity doesn't by itself violate discrimination laws that we just discussed, but disparities can trigger further investigation to determine whether the disparity is justified. Now we'll explore the disparate impact analysis specifically. So the analysis related to disparate impact involves a three-step approach, which we'll cover over the course of the next several slides. The first step in this analysis is to determine if your institution has a policy or a practice that produces an adverse impact on applicants of a particular race, color, or national origin when compared to other applicants. The reason we offer this disparate impact analysis is because in beyond-the-box situations, it's important to conduct a disparate impact analysis. So if in this first question your answer is no, then the analysis ends and there's no unlawful disparate impact discrimination. On the other hand, if the answer is yes, then you have to move on to the next step in the analysis. The second step asks whether your institution demonstrates that the policy or practice is necessary to meet an important educational goal. If the answer is no, then it is likely that there will be a finding of unlawful disparate impact discrimination. If the answer is yes, on the other hand, then you move on to the next step in the analysis. For this question, both the importance of the educational goal and the tightness of the fit between the goal and the policy or practice employed to achieve it is what's analyzed. So that brings us to our third step in the approach. The final step is to ask whether there are comparably effective alternative policies or practices that would meet your institution's stated educational goal with less of a discriminatory effect on the disproportionately affected racial group. If the answer is no, then the analysis ends and there is likely no unlawful disparate impact discrimination. If the answer is yes, then it is likely that there will be a finding of unlawful disparate impact discrimination. So now let's move on to some executive guidance that we have in place. The White House, the U.S. Department of Education, and the U.S. Department of Justice under President Obama's administration did create guidelines specifically for asking about an applicant's criminal record in student admissions. President Trump's administration has not withdrawn any of this guidance, and the relevant websites for this information are still up. Annie, we have one question that's come in, and I'm curious to hear your response to this. Even though the Trump administration has not offered what their opinion on this subject is, do you have any inclination about how the administration may have a stance on this particular topic?
We don't have any direct indication of what stance they'll take, but we do have an indirect one in that they have actively taken down prior labor guidance and, as many of us know, prior Department of Education guidance, and they haven't done that in the case of this ban the box issue. And paired with that, most of the legislation in this area, as we'll talk about when we get to employment, is driven at the state level, largely by advocates at the state level. So we haven't seen any clues indicating that this is an issue for the current administration or that they intend to change the guidance here. I think the trend is well underway at the state level to limit or at least control the use of the box in education and employment settings. And in addition to this White House guidance that is still up, there's a lot of EEOC guidance that is still up and Department of Education guidance from the Obama administration indicating that we should all use care in approaching the box in these situations.
I think that's absolutely right. I think that's why these issues in particular that we're talking about have so much state implications that it's really important to make sure you're aware of what your particular state is doing on this topic. And we'll cover some of that during the course of today's presentation. But continuing on related to the executive guidance that is still currently in place, a couple of years ago there was a push from the White House for colleges, universities, and other institutions of higher learning to participate in the Fair Chance in Higher Education Pledge. The link for the pledge is on your screen, and essentially the pledge was for schools to sign if they are committed to taking action to reduce barriers in education, including adopting fair chance admissions practices, like going beyond the box and determining whether criminal justice-related questions are necessary to make informed admissions decisions. There's also a corresponding fair chance business pledge promoting fair hiring practices. In May of last year, the U.S. Department of Education issued guidance related to asking about criminal histories on admissions applications. A link to that guidance is on your screen right now. This guidance was developed under the Obama administration, and like we mentioned earlier, has not been withdrawn by Secretary DeVos or the Trump administration. And so we still consider this good guidance. So we're now going to dive into that guidance issued from the Department of Education and really do an in-depth look at exactly what the considerations are. The overall recommendation that was provided by the Department of Ed was to provide justice-involved youth with opportunities to earn post-secondary degrees or training certificates, because providing these opportunities can help reduce unnecessary and overly broad collateral consequences of a criminal record. The guidance also provided specific considerations that institutions of higher learning should consider in inquiring about criminal histories on admissions. The first was to assess whether the use of criminal history questions actually furthers the institution's goals of creating a safe, inclusive, and diverse campus community. The second consideration was, to the extent a criminal record is used, schools should consider a multi-step approach in order to mitigate barriers to higher education. In that guidance, the Department of Ed cautioned schools about the unjustified discriminatory effect questions about criminal histories on admissions applications that they can have on applicants. There was research from the National Institute of Justice cited within the guidance discussing how young adults are in fact developmentally distinct from older adults, and that the brain's capacity for mature decision-making continues to evolve well beyond the teenage years. The guidance also provided that because collateral consequences of the justice involvement are particularly severe for young adults, institutions of higher education can assist young people who may have gotten off track in their younger years with their transition to productive adult lives. The next issue is to determine the necessity for asking such questions on admissions applications and whether it's necessary to make an informed admission decision. The circles on the slide are a diverse set of assessment tools that provide admissions personnel with a more complete measure of an applicant's potential for success and potential contributions to the higher education community. Many of the schools that are on the call now likely employ all, if not most, of these bubbles that are on your slide. The Department of Ed and the Department of Justice suggest several areas for providing an applicant a fair chance at admission. Two of them are on your screen right now. The first is related to timing and delaying when your schools request criminal records information. And the second is related to transparency, which encourages schools to make the inquiry about criminal history as clear to potential students as possible. Where we see the most amount of questions from our clients is related to this second issue of transparency and providing guidance on policies and procedures to ensure that the practices match the policies and that they're following the best practices of being transparent to applicants. I think that's often the most challenging piece of the beyond the box and the ban the box issues. The third suggestion for providing an applicant a fair chance at admission is consistency in admissions decisions, which can be accomplished by ensuring your policies match your practices and that they're being applied fairly and equally to all applicants for admission. The next one relates to sharing the results of a denial of admission. This recommendation from Ed and DOJ would have schools inform students that they were denied because of their criminal history specifically, rather than just what we see like a standard denial letter. The reason for the suggestion goes back to the concept of transparency and would allow students an opportunity to appeal the denial of their admission based on their criminal history. The appeal process allows applicants to usually share their story and any rehabilitation or other issues to consider that typically isn't asked when these beyond the box questions are asked on student admissions applications. Something to keep in mind as we're discussing criminal histories in admissions is the Title IV elephant in the room. A student convicted for the possession or sale of illegal drugs may have financial aid eligibility suspended if the offense occurred while the student was receiving federal student aid. This issue isn't to be taken lightly because the Government Accountability Office's report with the most recent data provided that 50,000 students in the 2013-2014 school year were denied federal student aid due to their convictions. So it's incredibly important that you consider ways in which you can assist your students with criminal convictions that may ultimately affect their federal student aid. Under the Obama administration, there was a specific executive initiative called the Second Chance Pell Pilot Program, which supported post-secondary education opportunities for those incarcerated in federal and state prisons. $30 million was set aside for this program, which is still less than 1% of overall Pell spending of just over $28 billion. Prisoners' full aid eligibility was worth up to almost $6,000 in 2016. These Pell Grants were limited to the equivalent of 6 years per student and can also support 1 year of developmental coursework a prisoner may need. The next topic to discuss, and one of the main areas that our clients have questions about when considering whether to remove criminal history questions, is the issue of licensing that Annie talked about earlier. The key here is to be straightforward about the issue of licensing. Let the applicants know that they are being asked questions related to their criminal histories because of licensing requirements. My undergraduate degree is in elementary education, and that's an example of a program where a state licensure may not grant a person a license to teach if they have a criminal conviction. It's important that if licensing is the basis for criminal history questions, then be sure the student knows that if they are admitted, they may not be permitted to be placed at some clinical sites or may not be able to secure a license. On this next slide, we provide an example of a waiver or acknowledgement in situations like the one we just talked about, where a school is admitting a student to a program despite negative feedback on a background check. Here's a sample language and a sample waiver and acknowledgement for all of you to consider in those situations. In terms of litigation and enforcement in this area, to be frank, it's very rare. Very few cases have been litigated about asking applicants about criminal histories. However, in the cases that do get litigated on this issue, the cases typically involve incomplete disclosures by the students. We'll go over one example of that case on this very next slide that comes out of New York. So this case involved a student who submitted an application to St. John's Law School where he only mentioned that he had been convicted of a drug possession. During his second year of law school, the student disclosed that he actually was originally charged with selling drugs. The particular question at issue that the school asked was related to charges as well. So this came to light during the character and fitness process that is required for admission to the New York Bar and many bar associations across the country. Because of the student's misrepresentation on his application, the school rescinded the student's acceptance consistent with its policies and procedures. Ultimately, the New York Court of Appeals rejected the student's argument and ruled in favor of the college. that they did not make an arbitrary or capricious decision. This next section will highlight the current methods of asking about criminal records by various colleges and universities. We will also provide some drafting tips that you may want to consider if you choose to create such a policy. So many of you are probably wondering how information related to criminal histories is used across colleges and universities nationwide. In a study that was conducted on this issue, 35% of institutions denied admission to at least one individual due to criminal history. A study conducted with almost 300 institutions also found that 66% of schools did in fact collect information about criminal history, but that only 40% trained their staff to interpret that data, and over 50% had no written policy regarding the admission of applicants with a criminal history, which often is where some of the issues related to consistency apply, when there is no policy that's in place. Now we're going to discuss some of the ways to ask the question or questions related to criminal history, and also provide you with some examples. The typical methods are listed on your slide. And something to note is that some of the country's largest colleges and universities do not inquire at all about criminal history. And many community colleges across the country have open enrollment policies and do not ask individuals to check a box or disclose any criminal justice involvement. Some of the folks on this call I noticed are one of the many institutions that use the Common Application, or Common App, which does in fact have a required criminal history question. And we'll discuss the Common App a little bit later in the presentation. For those of you in Louisiana on the call, your governor signed the state's own Ban the Box law this past June, which prohibits state higher education institutions from inquiring about a potential student's criminal history during the application process. In Maryland, on the other hand, the governor vetoed legislation that would have barred colleges from asking about a prospective student's criminal history on applications. On the slide that's on your screen now, here are some examples of the various ways schools ask about the criminal history question on their admissions applications. These examples show really the wide disparity on how colleges and universities inquire about an applicant's criminal history. On the next slide, the two examples shown also show the two extreme in regards to asking about an applicant's criminal record, one being very, very specific and the other being more general and requiring a lot more information. And so there's like I said earlier, there's a wide disparity that we see among our clients in various colleges and universities about how these questions really are being asked. The Common App, as I mentioned earlier, asks applicants a mandatory question about the criminal histories. The question is on your screen now, the full question. This question first appeared on the Common App over a decade ago in 2006. Over 700 colleges are using the Common App, about 23% of U.S. schools. Something to note is that schools using the Common App can suppress the response to these questions permanently and can even do so for just a time until they're ready to see that information. They can do sort of a delayed showing of that question and the answer. The Common App also asks a question about disciplinary violations at school. Similar to the criminal history question on the prior slide, this information can also be suppressed by colleges and universities, either entirely, meaning you don't see the question at all in the response, or it can be suppressed until a later time, so more of a delayed viewing of that particular answer. But the Common App isn't the only application that asks about prior disciplinary information. About 75% of institutions nationwide collect high school disciplinary information, including those pink slips that were given in high school. And almost 90% of those that ask about it use this information in admissions decisions, which is a much larger statistic than I think I initially anticipated. There are many schools, though, across the country that are also employing initiatives to support students with prior convictions or who have previously been incarcerated. For example, the University of California, Berkeley created the USI program, which supports all prospective and current UC Berkeley students who are not necessarily involved in incarceration, but are impacted by incarceration, imprisonment, or detainment. This program helps previously or currently incarcerated individuals transition into the culture of the campus. They provide peer counseling, scholarship information, and other resources to those students. Similarly, Rutgers University has a program that specifically recruits students from community college programs within New Jersey's correctional centers. The program at Rutgers offers continued support and guidance and assists previously incarcerated individuals after enrollment with navigating issues like financial aid, managing personal finances, course selection, and access to direct academic supports like tutoring and coaching, things along that nature. So now we're going to turn to issues dealing with employment, and I'll turn it back over to Annie.
Thank you, Alex. A lot of the issues related to employment criminal history considerations, particularly on college and university campuses, overlap with those issues that Alex just talked about. But we do have some additional guidance and some additional trends to talk about. So let's spend a few minutes looking at those and looking at the big picture legal and guidance considerations concerning the use of the box in employment. Well, we do have federal guidance, as Alex said, and as we'll touch on more in a moment. Many states and localities are moving on this issue in a way that the federal government has not lately. We have 29 states that have policies or laws touching on the issue of using the box in employment. Many of them either say by law or by executive order that public employers cannot use the box on an initial job application, and 9 states have actually removed the question for private employers on initial applications as well. And at the municipality level, over 150 cities and counties and towns have done that as well. Exactly what these laws say vary by jurisdiction. In general, they prevent employers from considering prospective employee qualifications on their first application by removing the criminal history question from the application, by delaying any background check inquiries until either after employment or further along in the employment process. If you are interested in knowing exactly what the law is in your state and your jurisdiction, I highly recommend this. This is an interactive map from the National Employment Law Project, which is aimed at helping those who've been incarcerated find employment. And if you click on your particular state, not only will it indicate what your state's law is, it will indicate which municipalities have laws or regulations or policies concerning the use of the box in employment. The federal government, of course, has offered us some guidance. The most relevant legal reference for employers is generally Title VII, but remember, we are talking about the education context, so it's likely that Title VI and Title IX may extend to our employment decisions, particularly our student employment decisions in the higher education setting. Though ex-offenders aren't a protected class, given the statistics that we've talked about earlier, where criminal history is more racial and ethnic minorities and men, we may be setting ourselves up for discrimination charges under these statutes if we are actions in employment. The White House has also issued a fair chance business companies have signed it. It calls on them to commit to achieve the goals of promoting individuals re-entering the workforce with a criminal history. This is guidance that, like some of the other guidance, like, for example, FLSA guidance that's issued recently. So our indication here is that it is still ongoing. And again, we have those agencies have also weighed in, most notably the EEOC, in various publications, but most thoroughly and most clearly in an April 25th and it provides a number of examples, I think fairly clear examples, of where we can draw the line and make decisions without crossing the arrests and asking about convictions. It notes that because certain groups are more likely to be arrested, eliminating someone based on an arrest without reports of convictions aren't 100% reliable, as we talked about before, and so the EEOC guidance recommends that we confirm the information we receive about convictions. The guidance indicates that it can be a violation even if you have a neutral policy of discrimination laws if you are not and that you are applying it in the same way to different groups. So don't apply it differently to white traditional 18-year-old students than you will same way. The EEOC also suggests that a facially neutral policy can have that disparate impact that Alex was talking about, and that we should take some steps policy based on a conviction, that we either look to some published uniform guidelines on employee selection. Those tend to be research supported or vetted. 2012 guidance. That means that we don't just say, okay, you were convicted of a crime, we're not hiring you. It means that we look at the at the time that's passed since the offense or the time that's passed since release from imprisonment. And then we should also look at the nature of the job. Is this a job of controlled substance violations may not be the right fit for the job. But if you are talking about someone who may be a groundskeeper with and not only does the EEOC say we should go through more of a case-by-case analysis when considering convictions in making employment decisions, get them to explain or to give us some additional information, and we should consider information before making a Department of Labor really supports this idea that's fleshed out very well by the EEOC. This idea